I just reviewed a living trust for a couple with about 5 million in assets. Beautiful documents, professionally drafted, signed just 3 years ago. And yet, it was filled with hidden problems that could have cost their child over $100,000 in taxes and legal fees. Here's the scary part. They didn't know. They thought signing the trust meant they were protected, that it eliminated taxes, shielded them from creditors, and covered everything automatically. None of that was true. Today, I'll walk you through the most common misunderstandings about revocable living trusts, what they actually do, what they don't, and how to make sure your trust really works when it matters most. Let's start with the one that costs people the most money, the belief that a revocable living trust avoids taxes. This is the most common misunderstanding and the one that creates the most financial damage. A revocable living trust doesn't reduce income taxes, capital gains taxes, or estate taxes by itself. During your lifetime, the IRS treats it as a grantor trust, which simply means it's invisible for tax purposes. Everything the trust owns is still considered yours. If it earns $50,000 in dividends, that income shows up on your personal tax return. When you sell trust property, you pay the capital gains tax, not the trust. And when you pass away, all the assets inside are still counted as part of your taxable estate. Here's why this matters. I've seen families set up a trust and then stop doing the real tax planning. No Roth conversions, no charitable giving strategy, no capital gain harvesting, because they assume it handles taxes. But it doesn't. Your revocable living trust is a management and probate tool, not a tax shelter. The tax benefits come from what you put inside it and how it coordinates with your overall strategy, investment structure, charitable planning, and step-up opportunities. Think of your trust as the foundation. The real tax savings come from the ingredients inside. Okay, living trusts don't reduce taxes, but they at least protect your assets from lawsuits and nursing homes, right? This one creates dangerous complacency. People assume that once assets are in a trust, they are safe from lawsuits, creditors, or nursing home costs. Not true for revocable trusts. As long as you are still alive and can change or revoke the trust, you still control the assets. And because you still control them, creditors can reach them. Legally, those assets are still yours. Let's say you have about $800,000 sitting in your revocable trust. Years later, one of you needs long-term care that costs around $120,000 a year. You might assume the trust protects those funds, but because it's revocable, Medicaid still counts that money as yours. You'd have to spend down a large portion of it before qualifying for any assistance. Your revocable trust gives you control, not protection. If you want actual asset protection, you need different tools: irrevocable trusts, insurance strategies, or other legal structures. Alright, no tax savings, no asset protection. But the main reason people create trusts is to avoid probate. That works automatically, right? Well, not quite. And this is the most expensive mistake I see. Your trust can avoid probate, but only if it's funded properly. If your home, investments, or bank accounts are still titled in your personal name, those assets will go through probate no matter how perfect the trust document looks. And it's more common than you think. Families spend thousands setting up a trust but never retitle their house, accounts, or investments. Years later, everything ends up in probate anyway, close to a year of delays and $30,000 to $40,000 in fees. Think of your trust like a blueprint. The documents are the design, but moving your assets into it is what actually builds the house. Without that step, you're left with a great plan on paper and nothing standing when it matters. Take a few minutes to check your accounts and property titles. If they don't list your trust, fix them now. That single step can save your family $15,000 to $50,000 and nearly a year of delay. Now, some people don't retitle their home because they're worried about what might happen. Maybe the bank will call the mortgage due, or the county will reassess their property taxes. Let's clear that up. Here's the truth. In almost every case, transferring your personal residence into a revocable trust doesn't change ownership in a way that would cause either of those things. Under federal law, as long as you are still living there and making your payments, your lender can't call the loan. And for property taxes, almost every state treats this as a non-event. You are still the beneficial owner, so your homestead exemptions and senior caps stay intact. So don't let that fear stop you. The real risk isn't transferring your home into the trust. It's leaving it out and forcing your family through months of probate. Okay, the home's funded, the accounts are titled. Feels like you're all set, right? Not exactly. A lot of people stop here and assume the trust covers everything. And that's where the next big mistake happens, thinking they don't need a will or power of attorney anymore. Wrong. You need both. Your trust only controls assets that are actually titled in the trust's name. Anything you forgot, like a new account, car, or property, still needs to be handled through a puller or a will. That document catches what you missed and moves it into the trust after probate. And just as important are your powers of attorney. Your trust manages what happens after you pass away. Your power of attorney handles what happens if you're still alive but can't act for yourself. Here's how this actually plays out. You and your spouse set up your trust. Everything looks great. But you never sign a financial power of attorney. Then one of you ends up in the hospital, maybe after a stroke, and the other suddenly can't access joint accounts or investment funds. Bills are due, but the bank won't talk to you without that document. The only option left? Go into court for permission, spending months and thousands of dollars just to do what a simple power of attorney could have handled in minutes. Your revocable trust doesn't replace your will or your powers of attorney. You need all three working together. The trust for estate management, the pour-over will for anything missed, and updated powers of attorney to protect you during your lifetime. And that's really the point. Estate planning isn't a one-and-done task. It's something you have to maintain over time. Which brings me to the next big mistake I see all the time. Thinking that once your trust is signed, you are done. This might be the biggest silent killer of good estate plans. Life changes, tax laws, family situations, assets all evolve. If your plan doesn't evolve with them, it can fail when it's needed most. I see this constantly. A couple creates a trust in 2015. Fast forward 10 years, they've moved states, bought property, lost their named trustee, and added new investment accounts. Have their assets untitled properly anymore, and their trust no longer matches their real life. The result? Confusion, legal fees, and family stress. A trust isn't a one-time project, it's a living plan. Review it every few years, or anytime something major happens. A new marriage, divorce, relocation, new property, or business sale. Keeping it updated is what keeps it working and helps you avoid those costly surprises that tend to show up at the worst possible time. And even when families do keep their trust current, there is one last misunderstanding that can be incredibly expensive, especially for your heirs. Many people assume that once assets are in a living trust, they will get a full step up in basis at death. But that's not always the case. It depends on how the trust was structured. If you and your spouse created an older bypass or credit shelter trust, only the surviving spouse's share may get the adjustment. The other half could stay frozen at its old basis. Here's a real example. You bought your home for $500,000. When the first spouse died in 2015, the house was worth $1.2 million. Their half, $600,000, went into a bypass trust and got a step up in basis to that amount. That basis is now frozen. Fast forward to today. The home is worth $2 million. When the surviving spouse dies, their half gets a fresh step up to $1 million. But that bypass trust half still stuck at $600,000. When your kids sell for $2 million, they'll face capital gains on $400,000 of appreciation, about $80,000 to $100,000 in taxes that could have been avoided if the trust had been updated. So even though everything is in the trust, not every trust qualifies for a full step-up. If yours was written before 2018, when estate tax exemptions doubled, it's definitely worth a review. Many old bypass trusts no longer make sense. A simple update could restore the full step-up in basis and save your heirs a huge tax bill down the road. And that really brings us to the big picture. A living trust works when it's kept in sync with your life. Here's how to make sure it still fits your life. Pull out your trust documents. Check what kind you have. Revocable, family, or bypass, and when it was last updated. Check for life changes, marriage, divorce, a new home, moving states. Any of those can throw your plan out of alignment. Look at what's inside. Make sure every major account and property title reflects your current situation, not how things looked years ago. Get everyone talking. Your attorney handles the legal side. Your financial advisor keeps the plan coordinated. The best results happen when they communicate. Think of this as routine maintenance. A few small updates every few years can prevent six-figure problems down the road. If you are realizing that your trust might not be doing exactly what you thought it was, that's okay. Most people don't find out until something changes. The good news? You can fix it now, while things are calm. That's the work I do every day, helping families see where their estate plan and finances aren't lining up, and bringing those pieces back into sync. If you want to make sure your trust still fits your life today, just use the link below to set up a short call. We'll review your current setup together and talk through what, if anything, needs attention. Now, once your trust is set up the right way, the next step is understanding how much control you actually want to give your beneficiaries. That's where the power of appointment comes in, and it can completely change how wealth moves through your family. Make sure to check out that video. And if you haven't already, hit subscribe so you don't miss more strategies like this. Thanks for watching.